Indian corporate world in April 2014 woke up to a new reality. Spending time, money, and efforts for the betterment of society was made compulsory for some companies in the form of CSR, that is, corporate social responsibility. In the sense, companies were asked to share the burden of social development. In this video, we introduce ourselves to the concept of CSR and the act that enables it. Corporate social responsibility relates to the responsibility of the corporates or business houses, especially bigger ones, to engage part of the wealth in philanthropic or charitable activities. On the lines of giving back to the society and conducting responsible businesses, which is a very novel concept, considering the impact of business on environment and sometimes displacement of people. But India seems to be the only country to made it mandatory by law, specifically discussing Companies Act 2013. Let us look at CSR under the Companies Act 2013 now. CSR activities are dealt in Section 135 and Schedule 7 of Companies Act 2013 and Companies CSR Policy Rules 2014, and it has been effective since 1st April 2014. It was notified by Ministry of Corporate Affairs, the ministry in the government which deals with forming directional policies for corporates. Thus, these rules provide for the manner in which CSR activities shall be formulated, undertaken, reported, and monitored. And Schedule 7 of the Act lists activities that can be undertaken as CSR, which means anything outside it does not qualify for CSR spend. There are few conditions which make CSR compulsory for some companies. Let's go through them. Company with net worth of rupees 500 crore or more, or turnover of rupees 1000 crore or more, or net profit of rupees 5 crore or more. Any company falling in above category shall constitute a CSR committee and shall spend in every financial year at least 2% of their average 3-year net profits in pursuance of its CSR policy. It is important to note here that every year many companies give the reason for not spending money on CSR activities as CSR committee was not yet formed or is in process of formation. It is a kind of loophole. Now the next obvious question comes in our mind is regarding the types of companies that come under CSR net. The answer is every company incorporated in India, including its holding or subsidiary, and a foreign company having its branch office or project office in India. It is important to note that CSR fund can be utilized by companies only in India and not abroad. Now we understood the applicability of CSR Act. So let us understand what comes under CSR spending and what not. First, let us go through spending that do not qualify for CSR. CSR projects or programs that benefit only employees of company and their families. One-off events like marathons, awards, charitable contributions, advertisement, sponsorships or TV programs, etc. Expenses incurred by companies for fulfilling other acts like labor laws, Land Acquisition Act 2013, Apprenticeship Act 1961, etc. Activities undertaken in pursuance of normal course of business. Project or programs undertaken outside India. It is important to note here that court has specifically directed MCA to treat medicine donations given by drug maker to poor patient as a part of CSR spending. And also, government does not offer any kind of tax benefit to CSR spending. Government is not in favor of offering tax benefit as it would be similar to offering subsidy. Yet, contribution to Prime Minister Relief Fund receives 100% tax rebate. Now let us look at few examples of spending which are eligible for CSR. Slum area development. Swachh Bharat Abhiyan, Clean Ganga Mission, eradicating hunger, poverty, and malnutrition, promoting healthcare, promoting education, employment enhancing vocational skills, livelihood enhancement projects, empowering women, setting up homes and hostels for women and orphans, setting up old age homes and daycare centers, animal welfare, agroforestry, conservation of natural resources, training to promote rural sports, nationally recognized sports, Paralympic sports, and Olympic sports. Contribution to the Prime Minister's National Relief Fund or any other fund set up by the central government for socio-economic development and relief and welfare. Contributions or funds provided to technology incubators located within the academic institutions which are approved by central government and rural development projects. But please remember, contribution to political parties are not considered as eligible CSR spending, though such spending get tax benefits. Though here we have covered the topic in short, a lot needs to be read time to time from various sources as it is ever evolving topic. This video was brought to you by Synergy Study Point Pune. Stay tuned for more such videos. You can also write to us on admin@upscmantra.com. And for more information, please visit our website www.upscmantra.com. Thank you.